You can waive your right to get it re-reviewed by the regional office by just simply submitting a letter to the BVA, letting them know that I'm waiving the requirement that you send the new evidence back down, and that you yourselves, the BVA, can just review it initially. And I have this graph here, or this model here, that essentially is just telling you that the legacy process took almost 4 years if you went through the entire process from the initial application to the decision by the BVA. So because that took so long, we now have the modern process, which Andrew is going to touch on.
Well, we're going to talk about this one a little bit more because, again, this is new. So if you've come into this with some experience and you know what we're talking about, this is the area where the law has changed substantially in the last year. So if all the problems with the legacy system weren't apparent, I will give you some more. It was designed, again, by very well-meaning people who thought they created an adversarial system where the parties aren't adversarial and there's no lawyers involved. The result of this is it's very adversarial and there's always lawyers involved. The idea is that the VA plays the role of the plaintiff's attorney, defense attorney, the judge, jury, the expert witness, and the appeals court, and they have an affirmative duty to help the veteran. And I don't think you can actually find a veteran who could speak of their experience as being true to that after going through this process. So a lot of the system doesn't make sense because for a normal attorney practicing the way that we practice in the courts of Texas, all of this looks like the VA gets to hold all the cards and decide everything, has all the information, and that the veteran and their advocate that they have chosen have none of them. Part of the problem is you talked about a statement of the case being 50 pages, which it can be correct, but 47 and a half of those will be boilerplate, just stating out the law as it's written, copied and pasted on there. It's not really helpful to just figuring out what's actually going on with the veteran. The part that's relative to the veteran, the plaintiff's injuries are not, or I'm sorry, the veteran's injuries are not related to service, is going to be a sentence. I'm not going to say useful information. And all of the notice of disagreements, all the appeals went through the same line. There was no express line. There was no, oh, I only have this, I want to add evidence. They all had to go in the same queue of people filing initial claims, anything that they were appealing, whether they were appealing everything, or they were appealing just one thing, it was all the same line. So the Appeals Modernization Act passed in 2016 and then passed again in 2017 with some minor changes to become law in 2019. The pilot programs that fed into it, the stuff they tried out, have been going on since 2014. So a lot of the stuff has already been tested in some ways in certain jurisdictions. The act that was passed was the Veterans Appeals Improvement and Modernization Act. The VA calls it the Appeals Modernization Act because they removed the improvements. The veteran can now choose a lane for their type of appeal. So this is a kind of a big deal now because instead of getting that same queue as everybody, you can now choose who you want to look at your case next. All of the appeals process, all the litigation stuff is being removed from the local regional offices. It used to be there was an office where they had thousands of paperwork stacked up to the ceiling of veterans' claims. All of that stuff is now in DC. The decision is supposed to now include the evidence that was, how the evidence was used in making that decision. Instead of just being able to state that the injury was not service connected, they now have to state why they reached that conclusion. They're now supposed to tell the veteran what findings they make that are favorable to the veteran that's going to be binding on them going in the future. There's a couple things that are bad for the veteran. Those are all the good things. The window for submitting evidence is a little bit narrower now. You used to be able to submit evidence, basically right up until the case was decided. Now there's a limited window to submit that evidence. And there's a habit that veterans have and veteran service organizations have that they just appeal everything the VA gives them. The VA said, no, appeal it right away, reflexive appeals. That used to be an okay answer because you could build your case after you filed an appeal. Now that's a bad answer. If you do that, you're going to very quickly get yourself into a path that takes you to the Court of Veterans Claims in DC and is going to require you to present the case more difficultly and cut off several avenues you have to get your case proven at the initial application, initial appeal level. So the legacy system, the AMA will coexist for a few more years. If your claim is in the legacy system, you can keep it there indefinitely. So it is the veteran's option to opt into the AMA. I don't personally see any reason why anyone would opt into it. I think it is significantly better than the old system, but there can be certain circumstances where veterans may want to stay in the old system. For the foreseeable future, the VA and veterans are going to confuse the two systems. And there will be people that work for the VA that knew how things were done for many years and are going to be slow to catch up to things that are done differently now. And there's going to be veterans that have a lot of experience working in the system, either on their own in other cases, that are going to be slow to get up to speed on how things have changed. So keep that in mind if you're entering the practice field, that veterans may be absolutely certain that things work a certain way, that they're just not up to date on how that has changed. They may also be right for certain kinds of cases, the legacy cases, and wrong for how cases work now. So the VA, in order to tell veterans what their new choices were, put out this flyer, and they put it on the wall. And if you're squinting to read this now, you're doing what the veterans were doing when they saw this on the wall. But this is the VA's way of telling you how to make a good decision with your case. Look at this, read the fine print, and then make a good decision. I'm going to give you those 3 lanes as well, but I want you to think of them in a more colloquial manner so that you have kind of something to remember it by instead of the technical terms. So you have 3 choices to make on your appeal now. You're going for a higher level review, supplemental claim, or Board of Veteran Appeals. If you're looking at a higher level review, what you're telling the VA is that they missed something, or that their response or denial didn't give a complete answer. It didn't address all the claims, it didn't address all the evidence. There was something missing on that statement of the case denying. Supplemental claim lanes says, I have more evidence now than when you denied me. So you denied me because of certain lack of evidence, I now have that evidence. Or they have new evidence that may change their mind, something they didn't have when they initially filed for the case and were denied. The Board of Veteran Appeals says, I want to speak to a manager. I think they got it completely wrong, and I want to escalate it to the next level of review. The more technical terminology of how they describe it, a higher level review is a de novo review of your claim. It's somebody taking a completely fresh look at it. That person is at the same level as the first person who looked at it. It's just asking someone else to look at the exact same evidence and come to a different conclusion. You're not allowed to submit any new evidence as part of a higher level review. Supplemental claims lane says, I have new and material evidence to my case. Their criteria for new and material is that on the denial, something that they address on denial as being a reason they didn't approve the claim is now being changed by this new evidence being submitted. So, for example, if you say a veteran incurred a service-connected injury while they were in the service and that now they are disabled, and the VA says, we agree that they incurred an injury, but their disability is not severe. If you get the veteran service record back and it shows more about the injury, that's not new and material evidence. The VA has already conceded that the injury occurred. New and material evidence would be relative to their current existing disability and severity. The Board of Veteran Appeals is taking it up a level. The board, like I said, the board now operates exclusively in DC, and you have to make 3 more choices if you choose to do this escalation. So you're choosing that lane, and now you've got 3 sub-lanes you're going to have to choose about how to go through that Board of Veterans Appeals process. But I want to talk about higher level review in more detail first. The goal is decision time averages 125 days. They're already behind on that goal, but it is still significantly faster than the legacy system at getting opinions. You can't add any new evidence, but you can make new arguments about existing evidence. So this is important if a veteran's initial claim is denied and they're getting an advocate on board for the first time. You as a lawyer are probably going to look at the same pile of evidence and come up with new and creative reasons of why that should be approved that weren't included in the initial claim. New arguments on existing evidence is allowed for higher level review. My main goal in imparting the higher level review as a great new tool is because it is the first time you can use something akin to a motions practice in a VA case. It used to be you had to put everything together, submit it all at once, and then wait years for an answer. Now, because of the faster turnaround time, you can ask the claims reviewer to make decisions that are binding on the higher level faster now. So you can ask them to make findings about the existence of a service-connected disability, about a stressor as part of their service at the higher level review stage so that you don't have to prove that case every time you're going to another step on the appeal. Supplemental claim lane is, again, looking for new and relevant evidence. The specific definition is up there. I think I used an example, but it basically has to address what the VA said was wrong with the case. So whatever element of the case they didn't feel was proved, it has to be materially relevant for. Though there's a definition written to this, I would also say that it doesn't need to be something to be all really cautious about, whether new evidence is material. The main goal that the VA was addressing here is not something that you all have problems with, but it's something that I think a lot of VSOs have problems with, which is just piling paperwork at the VA. Anything that comes across their desk sent to the VA, sent to the VA. And a lot of that stuff being redundant or not materially new. So I think this was the VA's way of saying they want to cut down the amount of paperwork they're getting as part of these appeals and make sure it's relevant to the claim they're trying to make. So like I said, you have to choose 3 more lanes after you choose your first 3 lanes if you choose Board of Veteran Appeals. So you can do a direct review, which is basically the same as a higher level review. No new evidence, but you're having somebody with more experience and more authority and hopefully making a different decision. You can do evidence submission and add new evidence to the case, but your evidence submission has to be submitted within a certain time period now before you can do it. Or you can ask for a hearing in front of an administrative law judge. Personal hearings are all in DC now. You can do a video conference hearing that is done out of the same regional office building they used to do the traveling board from. So they just put a big TV and a video camera up there now. The average wait for no direct new evidence is 365 days. Again, still a long time, but a lot faster than the old system. There is no average goal they have for ones where you submit new evidence or ask for a hearing. So it's my opinion that you're basically getting the same line as the legacy system people, and you're waiting several years for that. You've got a 90-day window to submit new evidence. If that is your route, meaning after you appeal, you have 90 days to give them the evidence. And we don't know what the average wait for hearing is yet. It's about the same as it was in the legacy system, so they're not really modernizing or improving anything once you get to this level. You have 90 days before the scheduling of the hearing to submit new evidence. The scheduling of the hearing means the date they inform you the hearing is taking place, not 90 days before the hearing, the date of the scheduling of the hearing. So the new improvement, the big thing that I think helps advocates and litigators on the AMA is that the decision has to include a lot more information. They have to identify, I listed them out here as they're spelled in USC, and I'm going to talk about them all in a little bit more detail. But all of these are beneficial to the veteran and the advocate for the veteran, because now they are given the task at the VA of explaining how they reached their decision. And they didn't used to have to do that. The reason that's really important is because it was always vague why they denied it. Sometimes they would say the evidence doesn't exist, but if your argument was, in fact, it does exist, it's on page 40 of this document you submitted, you used to have to wait 4 years to get somebody to look at that. Now you've got a lot faster way of doing it. They also have to be more specific about the elements that they're denying, the evidence that they're reviewing and making these decisions. They used to be able to say that the disability was not, or that the service-connected issue, for example, was not disabling. Well, now they have to cite the doctor that said that, or the medical records that support that, and they can't just make that conclusory statement without citing where they're getting that information from. So now you have the opportunity to do what is close to discovery and motions in a VA claim, which you didn't used to be able to do. And again, on the old system, the statement of the case used to tell you what they got wrong, but if you're looking for the 3 boxes to check to get a claim approved, it was just saying this box is not checked. Now it's supposed to tell you why it wasn't checked, so it gives you a real clear roadmap to approve the case. So you should be able to take a statement of the case now, look at it and say, okay, in order to get your claim approved, you have to convince your regular treating physician that your symptoms are a result of your military service. You can give them real clear instructions of what is wrong on the evidence side of the case instead of it being very vague. They're supposed to make identification of findings favorable to a claimant. This is brand new, but this is basically now they're supposed to say things that help your case along that they found based on your evidence. So I think the idea was that they would take these issues off the table for later review. So that's helpful to you if you're trying to build your case. Did you prove the stressor occurred while in service? If the answer is yes, then you don't need to prove that at the Board of Veteran Appeals or later. That's already taken to the grant. It's also a way to kind of paint the VA in a corner in what they're using to make the decision. If you know that the veteran is seeking further treatment and further medical records, and that stuff is coming, but you don't have it yet,